You're an Egyptian lord. You're Illuminati. If you do not help me,
I'm Illuminati.
I will sue you and criminally prosecute to the fullest extent.
Okay, I welcome that.
Court Uncut. What the people want.
Court calls the case, people. Well, seeing.
This courtroom has seen chaos before, but nothing like what you're about to witness. A defendant claiming trillions, accusing Elon Musk, Donald Trump, and even the Illuminati of plotting against him. Judge Simpson must somehow hold this together while the entire courtroom teeters on the edge of disbelief. Stay tuned, because this hearing spirals from confusion to pure madness.
Got it. Court calls the case, people versus Joshua Wara. Mr. LeBeau's case. Wara.
Joshua. Thanks, Your Honor. Mr. Warren, can you state your name, sir?
My name is Joshua William Wara. I'm representing myself in this case.
So you don't want to be represented by an attorney?
No.
Okay. All right. Well, I would say there come some perils with you representing yourself. You understand that, sir?
No. I know
You
the
don't
mission.
understand?
I'm a jailhouse lawyer. I know what I'm doing. You are working.
I'm sorry?
You are being paid by Adolf Mack to fry me. This is conspiracy for murder. Your wife, Delphia Simpson, came up here pretending to be Ann Arbor Comprehensive Care Center yesterday. You are originally the Tux family. You are an Egyptian lord. You're Illuminati. If you do not help me,
I'm Illuminati.
I will sue you and criminally prosecute to the fullest extent.
Representing yourself in a felony case is already a gamble, but Joshua Wara just took it to a new level. Instead of focusing on the charge, a serious hit and run causing injury, he's launching into conspiracy theories. Judges must advise defendants of the dangers of self-representation, but Wara's confidence borders on delusion. Viewers, what would you do if someone accused the judge of being Illuminati in open court?
Okay, I welcome that. You're invited to do so.
Simpson.
What do you want to do with your case today?
Ellen Wara, Adolf Mack, Jeffrey Peak, Cynthia Miller, Frank Stanton tried to set me up, along with Derek Miller and Ryan Miller.
Okay, but I've got to do something. I've got to do something. I've got to do something with your case.
Huh?
I've got to do something with your case. What do you want me to do?
I would like to sue. And what am I in court for today? And I would like to prosecute to the fullest extent.
Okay, so
And
let
I
me
can
do
sue
this.
for 10 times the amount of what was stolen from me. They stole $666.8 million from me. They then turned it into 5.5 trillion and then put a hit out on me. I legally can sue for 10 times that amount, which would be $550 trillion. And I can criminally prosecute to the
I'm with you.
Which is
I'm
my
with you.
right.
I did that. I did the math too. Listen, here's the thing. I have to advise you, because if you are going to represent yourself, what you're here on.
Now we hear the real charge. Failing to stop at the scene of an accident causing injury, a felony. The judge tries to explain calmly, but Joshua answers with $550 trillion in damages. That's not just off the rails. It's orbiting another planet. Still notice how Judge Simpson never loses composure. That's professionalism under pressure.
Okay.
I'm doing it over Zoom.
So you're here on a complaint that alleges that on October 15, 2025 on South Main Street
the Pentagon's
in the
using
city of
prisms
Ann
to make
Arbor,
the
Washington
Zoom,
County,
mess up.
that you failed to stop at the scene of an accident regarding resulting in serious impairment or death. Do you understand that charge?
$1 trillion.
Yeah, sure. And that's a felony, punishable by up to 5 years incarceration, a $5,000 fine plus court costs.
which is actually 10 times the amount because I can sue because it's conspiracy to murder. And sovereign law would make it 100 times the amount, but since it is conspiracy
Okay.
to murder,
Well,
sovereign
I'm
law
with
does
you.
not
I
exist.
got you. I just have to let you know what you're
Which
charged
means
with.
I can sue for
There's
1,000
also a
times the
count
amount.
2 on the complaint that
Legally.
alleges that on that same date and at that same time, that you did commit a moving violation causing serious impairment of a bodily function. That's a misdemeanor punishable by up to 93 days, $500 fine plus court costs. You understand that?
Yes.
Okay, so there are serious perils representing yourself as opposed to having counsel. I would just have to advise you, you'd be treated the same. You are charged with making sure that you have an understanding and that you abide by the Michigan rules of, that you abide by the rules of evidence and the rules of procedure. You understand that?
Yes, Senator Simpson.
All right. And the other thing that I have to advise you of is that at any point during these proceedings, you wish to have counsel.
No,
then
I do
all
not
you
want
have to
any
do is
counsel, and I
just
want a bench
listen-
trial,
listen
not a
to what
jury
I'm
trial.
saying.
Because a bench
And
trial
then
is
if at
based
any point
on
you do,
objective evidence.
if
A
at
bench
any
trial
point
is
you
subjective
do
evidence.
want counsel, you just have to let the court know and the court will make sure that you have counsel.
When a defendant starts mixing sovereign law and conspiracy to murder in one sentence, you know the judge is fighting to keep this from collapsing. These sovereign citizen claims pop up often, but legally they mean nothing. The judge stays patient, explaining each charge, even as Joshua invents trillion-dollar lawsuits mid-hearing. Could you keep a straight face through this?
No,
You
I do not
understand
want
that?
counsel.
Okay, so what do you want me to do with your case today?
I
Now
would like
that
to
I've
do a
gotten through
bench
that
trial
part.
because a bench trial is on subjective
bench
evidence
trial?
and a jury
Well,
trial can
that's not
be
gonna happen.
bribed. And they're trying to
Okay,
bribe the
you
jury.
can go to
So
circuit
I
court and
want
have a
to
bench trial.
prosecute with sovereign law and it's conspiracy to murder and Donald Trump and Elon Musk are involved and I can sue for 1,000 times the amount. And sovereignty
Your Honor,
does
if I
not
can
exist
if I
because of the
can
amount of money that
I
they
don't know,
put
I've
that
not
they
been very good at
outline
it, but
and Donald Trump and Elon
oh,
Musk and Adolf
so-
Mack and Doug Minkoff and Jeffrey Peake and Ellen Wara all have estates that and residencies in states that do apply the death penalty. I would like to get
okay,
Mack
okay, I'm
and
with you.
Chair.
I got you. Let me hear from somebody else real quick.
Now it gets heavier. The defendant drags in names like Trump, Musk, and entire militias, insisting they're part of a murder plot. This is where judges must quietly assess mental competency. The legal term? Fitness to stand trial. If a person can't understand proceedings or assist counsel, the court must pause and order evaluation. Judge Simpson's calm tone here isn't casual. It's calculated caution.
Your Honor, if I was working with Mr. LeBeau on this file, I was going to be asking for an adjournment as this is a new file. The defendant is on surveillance video at the intersection of this crash causing this accident and then fleeing the scene. That has not been provided to either the defendant or his attorney if he has
I'd like to
one.
give
So
Donald
we would
Trump the
need more
elected
time.
chair.
The defendant's on parole, and if he's entertaining the idea of representing himself, I think it's important that we refer him to context first.
Well, I don't know that I can do that right this second, although maybe. But here's what I'm gonna do, sir.
Simpson.
I'm gonna adjourn your
I do
case
not want a
out.
jury trial. You cannot adjourn this. This is a high profile case. Where I can't, yeah.
Okay, but you
There's
haven't
too
seen
many
the
people involved.
You
You have a
haven't
Neuralink
seen.
in your brain and you are being manipulated and bribed and conspired against for murder by the Nazis. You will work with me.
Alrighty then. So you don't want an adjournment?
No, I do not want an adjournment. I want a bench trial.
Okay, so
It's
so
based on
listen.
factual evidence. The jury
No,
trial can be bribed.
I hear you. So the only thing that can happen is I can set this for a preliminary examination, but you haven't seen all the evidence.
I don't need all the evidence. I know all the evidence. Let me get a discovery
Okay, then.
packet though, so I can represent
So-
myself though, please. With all evidence, I would like to.
You want to
subpoena
represent
all records
yourself.
and all evidence.
All right, listen. Okay.
I would like to
So you want this
subpoena
set for
Bill
preliminary
Juarez.
examination?
I would like to I would like to subpoena Bill Wara. I would like to subpoena Scott Casey, the Michigan militia, all of their phones, Doug Minkoff, Jeffrey Peak, Adolph Mack, Donald
We're not
Trump,
bringing out. those people
Elon
then.
Musk.
Yeah, okay. If you want to subpoena them, then you can.
We just hit one of the wildest moments, Joshua demanding subpoenas for Elon Musk, Trump, and the Michigan militia. Legally impossible, but the judge lets him speak, building a record of the defendant's mindset. This is Courtroom Management 101. Let the person vent, then steer back to the law. Still, you can feel the tension. The courtroom walking on eggshells between compassion and control.
But I'm not bringing all those folks. My problem is he's asked for his exam. So I will have to set it. I wonder who'd like to hear this.
Your Honor, would we still be on the case?
Hang on, I'll get to that in a minute.
Thank you, Your Honor.
So I'm gonna indicate he doesn't want his discovery. Says he doesn't need it. Would they? Man. I'm not gonna have the complaint that's rights infringement, so yes, I'm gonna do it. And you're gonna be mad. It's okay.
You don't care about my feelings.
I don't care about your feelings because you don't care about mine. But we shouldn't air this in public. What? I have to do the, no, I can't. I cannot. So I have to do it. I got you.
Okay.
I hear you, but I can't do that. So here's what I'm gonna do. I'm gonna set this for defendant invoking what he has. Would prosecutor have their witnesses available the 28th?
Yes, sir.
Sir? I'm gonna
Yes.
give you your preliminary examination. So your preliminary examination will be set in person on,
Your Honor, I'm so used to
And,
just saying, yes, sir.
Adolf
no, I
Hitler
know,
is in
but
the
I
judicial
realize it's
court
close, but
with Carol
it-
Conkey in East Hope, et cetera, et cetera.
excuse me?
Carol Conkey is involved. She is at 22nd Judicial Circuit Court with Feiger and Ellen Wara and Jeffrey Peak. Elon Musk is with Trump at the Michigan Supreme Court in Lansing. I do not want to adjourn. I want a bench trial now.
I am not adjourning. I'm giving you the quickest preliminary examination I possibly can.
Yes, sir.
But I have to hear from all sides regarding that. I would set it for the 28th. Counsel, most of these witnesses are police witnesses, so we could at least begin.
Okay, thank you. What's today?
That's a yes or no.
Yes, sir.
Thank you.
What is today, Cedric Simpson?
Just when it seems over, Joshua drops another bombshell, saying he's executing someone and suing for Chase Bank. That's a red alert. Threats like that can trigger a direct contempt hearing. The judge, however, stays ice cold, pivoting back to scheduling the preliminary exam. This is what separates seasoned judges from rookies, composure when the courtroom melts down.
Pardon?
What is today, Cedric Simpson?
Today is the 23rd.
Okay, Miss Lee, I'm sorry that I'm executing your husband.
You're executing what?
Miss Lee's husband, who is Adolph Mack. I'm giving him the electric chair. And I'm
Fine.
suing him for everything he owns. He's JP Chase Morgan. He owns Chase Bank. I want Chase Bank. He's Hitler.
Okay, all right.
I'm suing for Chase Bank and giving JP Morgan Chase, who is Adolph Mack, the electric chair.
Okay,
If
thank
Elon
you.
Musk works with me
Okay, so here's what I'm gonna
and
do.
Donald Trump.
I don't know that we'll be able to go, given how you're
Yes, we
acting,
will.
but
I want
I'm
a
gonna
bench
set
trial
your
today.
preliminary examination.
I am sorry, Cedric Simpson, that the and Adolph Mack, JP Morgan.
I'm gonna set your preliminary examination for October 28th, 2025, 9 a.m. That will be before me. I'm not, if I let the PD off because I may on my own motion be referring for competency, I will do it that day. But so right now, to answer your question, Mr. LeBeau, you are still on the case. Because I think the more the merrier.
And just like that, case adjourned. But this entire exchange will likely end up in a competency evaluation. Judges can't proceed if mental stability is in question. Expect psychological assessments before any trial date moves forward. The law demands due process, even when defendants sound completely detached from reality.
Thank you, Your Honor.
You're welcome.
I-
No, you're not really thanking me, but I get it. All right, thank you. Thank you, sir. First case of the people versus Theophilus Smith. Two cases.
I just felt some people.
Theophilus Smith.
Yes,
I've got you, Mr. Smith. I'm waiting on your attorney. Whose case? is
yeah,
this?
who is the attorney?
Mr. Brown's case.
Yeah, I would like to fire my attorney immediately. I like to
Of
fire
course
my
you would.
attorney, fire all representation.
All right. We'll get to that in a minute. Maybe he knows already, which is why he's in here. Sorry about that.
Okay.
Mark Brown, Deputy Chief Public Defender, being on behalf of Mr. Smith.
So that you're aware, you weren't in the courtroom. Mr. Smith did identify himself, so I'm not gonna ask him to do that again. And he indicates that he wants to fire all his representation.
I understand, Your Honor. Has the court received an updated competency report?
October 22nd.
Yeah, I speak on that because I'm representing myself.
The report. The last report I have is from July, but it was
No, the only report, the only
marked that
copy
we
I took,
received
Judge
it
Simpson, the only
on
copy I took was
October
on February
22nd,
22nd.
but I don't know that
February
that. Okay,
27th.
Mr. Smith, we both can't talk. Okay, I'll hear you, but we both can't talk right now. All right.
Your Honor, we have,
But I don't know if that, so to finish that thought, I don't know that this is an updated report because it's dated July.
Right.
Maybe you have a 2-week adjournment so we can try to figure out what's going on.
Weeks?
so I will say,
No, want more? No, go ahead. What?
I will say this for the record. Your Honor, I believe the last report has indicated that Mr. Smith has not yet gained competency. So I'd ask the court to not fire me from his representation.
what?
To not fire me from.
No, I'm not. Yeah.
Thank you.
You already knew what my decision on that was gonna be. What I'm gonna do, Mr. Smith, is I'm adjourning your competency hearing. We need to get more information and then I can act on whatever you may want me to act on. But. Yes, Mr. Smith, what do you want to say?
I would like to fire Lauren Brown if I need to get representation. Me and my mom, we got plenty of money. We can hire somebody to represent me. I will no longer want a public defender like him. I do not want him. He haven't been to see me. He don't know none of my angles. He don't know anything. And first of all, I do not need a competency exam for a $1 prohibited fire act case.
Well,
the case is arson. It's only a case that I burned the box. It was only a $1 box that got prohibited. It was a prohibited fire act. The smallest.
Okay,
I do not
so-
need a competency exam for
Mr.
that.
Smith?
okay, so Mr. Smith, I can't do anything till I get that report.
Well, can I speak
Okay.
on bond then?
So
Because I
since
mean, I think it's
so
ridiculous the way I'm being.
Mr. Smith, since I can't do anything, I'm not gonna do anything. I understand what you're requesting. I get all of that, but I need an updated report to try to figure all of that out.
But the thing
So,
about it is,
I
I never
heard
wanted a
everything.
competency exam.
I know you don't,
These lawyers
but
are doing what they want to do.
Okay,
Nobody's communicating with me and they're doing what they want to do. I wanted to speak on bond. Ain't nobody talk about when I'm getting out of this place because I'm being.
well, you're not helping yourself with regard to that argument.
Yeah, that close that.
So I'll adjourn this to November 13th. Why not? 2025, 9 a.m. It'll be a good week. Bond at this point will continue. Thank you. Thank you, Mr. Smith. We'll see you in a couple weeks.
This case reminds us how fragile justice can be when mental health and the law collide. Judge Simpson balanced patience with authority, and that's not easy. What do you think? Should this case even reach trial or go straight for psychiatric review?